Good evening. We begin tonight with the recent decision by the Supreme Court that lowers the bar between church and state. Today, the High Court sided in favor of a Washington State high school football coach who got fired for praying at the 50-yard line after games. Now, the justices ruled 6-3 that the school district violated Joe Kennedy's First Amendment rights, saying the coach's prayers amounted to private speech protected by the First Amendment. In the majority opinion, Justice Neil Gorsuch wrote, quote, "The decision was based on mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike," end quote. Justice Sonia Sotomayor wrote the dissenting opinion, saying the decision, quote, "elevates one individual's interest in personal religious exercise in the exact time and place of that individual's choosing over society's interest in protecting the separation between church and state," end quote. And as this decision came down today, we look into what this means now for religious practices in public schools across the country and here in California. 23 ABC's Vanya Patino spoke with a political science professor at CSUB specializing in religion about the expected implementation of this case now. Vanya.
That's right, Keely. Well, to clarify, this decision does not mean that a teacher could simply decide to start the day with a class prayer, but for some it can push the limits of what we think of when we say separation of church and state, which the political expert I spoke with says has always been inconsistent. Across the country and here in California, public entities, including public schools, cannot have state-sponsored forms of religion, which is what the school in the Kennedy versus Bremerton School District case was arguing. However, the majority opinion from the courts today said the coach utilized religion in a personal way, not related to his employment as a coach.
In terms of, exactly what it might do in California and other states, I just think it opens up for challenge, and people that work in government may now feel more comfortable to have more outward showings or displays of personal religious beliefs and test those lines.
She adds that by ruling in favor of the coach, they also overturned the precedent set by Lemon versus Kurtzman, which is what had been used since the 1970s to decide if religious activity could not stand in a public entity. Dr. Craybill also says this decision is historical, as it is continuing the pattern of the majority of the current justices viewing the Constitution in a historical manner. She says because there is a fine line between what is personal religious expression and state-sponsored, staff need to be careful in terms of the environment and the event and how they present themselves. Meanwhile, the California Department of Education saying they are reviewing their policies to see if anything will have to change. Live in studio, Vanya Patino, 23 ABC News, connecting you.